Good afternoon, Chief Justice and
Did I pronounce
Commissioners.
your name correctly? It's Chithi.
Indeed, Chief Justice.
Right. How are you?
I'm fine, Chief Justice, under the circumstances. How are you?
I'm fine as well. Thank you.
Thank you, Chief Justice.
You were born in Kofimvaba.
Indeed, Chief Justice.
And in true form of people from that area, you have kept close ties with Hobuli Goduga.
Yes,
That's
indeed.
one of the comments
Yes, I am.
by the professional bodies. That's a good thing. You obtained some of your legal qualifications from the University of Transkei.
Yes, Chief Justice.
AP Proc and LLB.
Yes, Chief Justice.
And then you obtained a Master's of Law from UNISA
Yes, Chief Justice.
in 2004. You had started working as a candidate attorney at the UNITRA Law Clinic
Indeed, Chief Justice.
in 2001.
Indeed.
But once you obtained your articles, you went to work as a professional assistant
I
at
work.
the LHR.
Indeed, Chief Justice.
And then how long were you with the Lawyers for Human Rights?
I was there almost for a year.
Was that in Umtata?
In Umtata, indeed.
All right. And then you moved to KZN.
From Lawyers for Human Rights in Umtata, I moved to Legal Aid Board in Queenstown.
Oh, yes. Where you remained for just over 2 years
Yes, indeed, Chief Justice.
before moving to KwaZulu-Natal.
Yes, indeed.
Legal aid still.
Legal aid still in Umlazi.
And you remained with legal aid until 2008 when you decided to go to the bar.
Indeed.
Right. Is that where you still are?
That is where I am, Chief Justice.
So how many years have you practiced as an advocate?
If my counting is
About
not
16 years?
for between 15 and 16 years, Chief Justice.
And you're an attorney for about 6 years?
Indeed, Chief Justice.
Okay. What kind of work have you been exposed to, both as an attorney and advocate?
The kind of work that I have been exposed to as an attorney at Lawyers for Human Rights, initially it was civil work before Lawyers for Human Rights entered into a cooperation agreement with the Legal Aid Board, wherein some of the criminal work that the Legal Aid Board was doing was transferred to Lawyers for Human Rights. Thereupon, I was introduced to criminal work, which I did until all the various stints which I had with offices of the Legal Aid Board, both in the Eastern Cape and in KwaZulu-Natal. So I was doing purely criminal work from the time the cooperation agreement was entered with Lawyers for Human Rights until such time that I left Legal Aid Board in Durban in 2008.
You have acted as a judge both in the Eastern Cape Division of the High Court and in KwaZulu-Natal, where you want to work now permanently.
Indeed, Chief Justice.
How many acting stints did you do in the Eastern Cape?
I had one acting stint in Eastern Cape, which lasted for about 7
month.
weeks.
Just over a month. And what kind of cases did you adjudicate during that brief stint?
I had one criminal case which I presided over when I came there, and which I did not finish. And the JP then allocated civil work to me, which I did in Umtata, in Gqeberha, and in East London.
All right. Then shortly after your acting stint in Mthatha, you were invited to act
Yes,
in this division. You want to join permanently.
yes, indeed. While I was working there, I was phoned by acting Judge President Madondo to act for the session that was going to begin in 2013.
And
In
you
2023, I'm sorry
Yes.
about 2030.
then you went back for another session last year. Well, two sessions, two
I,
further sessions last year,
indeed.
and another this year until June.
In fact, I had 3 sessions in 2023.
Oh, I see. So in all, you have 4 sessions
In all,
in KZN.
I've got 5 sessions in KZN.
5.
I was invited to act for the session which started at the end of July and
Oh, I
ended
see.
sometime in August.
All right. Did you pick up any reserve judgments during your last acting stint?
I have a reserve judgment, Chief Justice.
How many?
It's one reserve judgment. It is one of the matters which I have referred to in my questionnaire.
Yeah, you listed 3. I take it you delivered the other 2.
The other judgments were delivered, but it was listed as a matter which was partly heard. I heard that matter during recess in July and concluded it. It is the one in which I have a reserved judgment. In fact, that judgment is with the researcher, and I got communication from her yesterday that she will be looking at it in the course of this week, going towards next week, and it should be ready for delivery sometime next week.
All right. What kind of work were you exposed to in the KwaZulu-Natal Division?
I was exposed both to civil work and criminal work.
And you wrote judgments,
I wrote judgment.
quite a few.
I wrote about, when I counted, if my count is correct, I wrote about 28 judgments in total, including the judgments in the Eastern Cape. The one that is with the researcher will be the 29th judgment.
Any reported? You listed 4 reported judgments.
Yes, there are 4 reported judgments, and those mainly are those when I acted in the Eastern Cape.
All right. All right. I'm going to ask Judge President Boyo Tloti to put questions to you, if she has any.
Thank you, Chief Justice. Good afternoon, Advocate Chithi.
Good afternoon, JP.
Yes. How was your acting stints in both Durban and Pietermaritzburg?
I have found them enjoyable, JP. I enjoyed my time mostly in Pietermaritzburg.
Yes. And we can disclose here that you were very reluctant to make yourself available because you're still earning good fees. And as I understand it, you're waiting for the letter to appoint you as senior counsel.
Yes, indeed. I still waiting for my letters, patent. I was very reluctant, but I reflected on the issue, consulted with my family, consulted with my senior colleagues in the profession, and upon reflection, I thought I might as well come when I still have energy and not wait until very late when my contribution might be minimal.
Yes. And I note in your CV that you have a passion for training.
Indeed, I have a passion for training, JP. I think that passion came from the difficulties which I had noted in relation to the time when I was at the University of Transkei, particularly with bookkeeping. Over time, I realized I was doing better than others in that subject. So I took it upon myself to help my fellow classmates. Later, when I had gone to do articles of clerkship with UNITRA Law Clinic, I still had that thing in me. Many people approached me. I assisted them. Over time, I realized I might as well do it because clearly a number of people are dependent on me. When I moved over to KZN, I was surprised that it continued to an extent that I remember one colleague of mine who was desperate to pass it. He had failed it 3 times. He came over from Butterworth, lived here in KwaZulu-Natal. I prepared him for bookkeeping, and when it was time for him to go and write board exams, he went over to the Eastern Cape and he reported to me later that he had managed to pass. Unfortunately, for the period in August, I was approached again, but unfortunately, I was working on second. I could not be able to help, but usually, both in the sessions in February and August, I usually assist candidate legal practitioners with bookkeeping.
And I saw that you continued with that. You still do, even though you're no longer an attorney, but
Yes.
an advocate.
Yes, I still do, JP, because I'm a member of the BLA. So by virtue of that, it is my responsibility to ensure that I continue to assist, despite the fact that I may no longer be an attorney, but an advocate.
Yes.
I also was requested by the Society of Advocates of KwaZulu-Natal to assist with tutoring in criminal law and procedure, and I have been doing that since 2021 to date.
Yes, and should we just add voluntarily? You are not getting paid for it.
Insofar as bookkeeping is concerned, I'm doing it voluntarily, but when the bar comes knocking to your door and say, would you be in a position to assist? You usually have to oblige, at least at the level of the bar.
Yes. Then the other thing that you seem to have assisted greatly is the issue of briefing patterns when you were, either you are still serving or when you were serving in the bar committee. Can you tell us a bit about that?
Insofar as the question, this is one of the problematic issues which we as the bar, I would say in KZN, are grappling with. It's an issue that we have found there, and we have found people who grappled with, such as the late Advocate Mchithi and Judge TV Norman. When the late Advocate Mchithi passed away and Judge Norman was appointed to the bench, we took it upon ourselves to continue with that, to ensure that those who came late to the bar did not find themselves closing shop and going home. So to that end, I've worked with one of my colleagues in one project in which we introduced juniors to eThekwini municipality. I prefer not to mention the colleague that we pioneered that project where we introduced junior members to the municipality in eThekwini.
Thank you. And in acting in the KZN division, one of the great things that you have done for me as the JP in particular is that you agreed to do a criminal session on circuit in Scottsboro, because that usually doesn't happen, that we send acting judges out on circuit, but you happily agreed to do that.
I happily agreed to do it because I have got no difficulties per se presiding over criminal cases. And even if I did, when duty calls, you've got no reason to say no. Even if it was an area of law I was not comfortable with, I was going to be duty bound to do it. But I found it easier to do it. I know the area, I've worked there before when I was working at Umlazi. I know the area well, so it was easy for me to agree to do that stint in Scottsboro as an acting judge.
Yes, and I see from your CV you do quite a lot of matters in the land court.
Indeed, I do quite a substantial portion of matters in that court. Indeed,
Yes.
JP, yes.
So part of the skills that I would imagine, or something that might help that court, and I know that they go through that process, is mediation.
Indeed, it is mediation.
And have you had an opportunity to assist in mediating some of the matters?
No, JP, I haven't had an opportunity to mediate the matters, but it does happen that those matters at some point are so fiercely defended. I would mention a big matter that we had done with was a group of advocates and attorneys. Did it in Melmoth. It was a problematic land claim. That matter was resolved by way of a settlement. It was not tried. So when you deal with the land claims matters, sometimes you find those situations where the landowners are willing to talk, and you engage yourself in that painstaking process of having to negotiate with the landowners, ultimately come up with a settlement.
Yes. To go to the next question, I want to start with this one. Have you ever been found guilty of misconduct by any professional body from the time you started and up to date?
I have not been found of any misconduct.
Yes.
JP.
This then takes me to the objection by, I think, the LSSA about the judgment that we are awaiting at the SCA. But more importantly, the judgment by Kanka AJ. I had an opportunity to read it, and without going to what the SCA might say or not say, what surprised me was the fact that if you want to, perhaps let me rephrase and say, if you want to issue a court order against a legal practitioner, what is the usual way in which we do that?
It is set out in a number of cases, like the case of Black Sash and many other cases. And we had drawn this to the attention of the court, that the procedure that they sought to adopt was incorrect at two levels, both substantively and procedurally. But despite us drawing that to their attention, we were never listened to. The procedure is that as soon as that order is contemplated, a rule nisi is issued, calling upon that particular legal representative to show cause why that particular order should not be granted. That is what we complained about. That if this is the order that you are contemplating, this is the procedure that you should adopt, so that we did not have to find ourselves having to defend the claimants on this side while we have to defend ourselves on the other side. But that was never listened to. We were indicted there, convicted, and sentenced without trial.
Yes. I know that we're waiting for a judgment there, but my understanding from the discussions we had before you even made yourself available was that the one judgment was out and the SCA had, the appeal was upheld. And in your view, in our discussion, it was that judgment and the one that we're waiting for a judgment from were almost the same in all respects.
Indeed, if I would call these two judgments, Mavundulu and Luhluni judgment, the Luhluni judgment, the SCA deleted that order which related to us for the same reasons we had complained about, that this is not the procedure. If for one reason or another, the order which is contemplated would be justified, then at least the procedure, which is an established procedure, should be followed. The SCA in September of 2021 deleted that order which related to us and found that there was no justifiable reason why that order should have been granted. Now, insofar as the Mavundulu judgment, if one looks at that judgment, particularly paragraph 66, the honorable judge there says, I am bound by the Luhluni judgment. That on its own, once that judgment was set aside insofar as we were concerned, it followed naturally that the Mavundulu judgment, at least insofar as the issue of whether that claim was frivolous and vexatious, it had to take that course too.
Yes. And then I'm not going to ask you about judgments because from the ones that I have seen, I don't have issues. But maybe my final question is, what in your view are the attributes of a good judge? And highlight for me those that you might possess if you have any.
Judge President, there are many, but perhaps I might want to emphasize those that I might bring along with me if I am recommended for appointment. One of those is Ubuntu. It's courtesy. It's patience. A human being has 2 ears, but I recommend that one should be able to bring a third ear, so that in a situation where you are in court, you have formulated a prima facie view on the matter which is before you. You would have enough patience not to listen to 2 ears in terms of the prima facie view which you took, but use the third ear and allow a hearing, even if you have a prima facie view. So those are the attributes that if I were recommended for appointment, I would bring along with me.
Yeah. CJ, I know I said that was my last question, but there's just one more that relates to that complaint again. In the other matter where they say you did not hear it because it sounds as if you ran away from dealing with a matter. That matter, I was in Devon with you when that matter came and more papers were filed. You came to discuss it with me because the other side was ready to proceed, but the other one was not ready to proceed. Maybe you can just tell us briefly what happened there.
What happened in that matter, Adv J had granted an interim relief and issued a rule on the 8th of September of 2023. The rule was returnable on the 15th of September 2023, which that date happened to be the date on which I happened to be a duty judge in motion court. A day before the hearing on the 15th, heads of argument came in that matter to my chambers through my registrar. I was reluctant to accept those heads of argument, but I decided against not accepting them. That perhaps there is something that is said in them. I took them, I considered them. The insistence in those heads was that the matter was to proceed. That surprised me because the matter was not allocated as an opposed matter. So when the matter was called, counsel who appeared for the applicant insisted that she wanted the matter to be heard, while counsel for the other side said the matter was not ripe to be heard and it was not set as an opposed matter. So it was not possible that the matter could be heard. So what I did was in motion court has to be fast. I requested the parties to speak and I stood the matter down to enable them to speak and craft an appropriate order. And indeed, I stood the matter down. When the matter was recalled, the parties had crafted the appropriate order, which was to the effect that the matter was going to be adjourned sine die. The respondent was granted leave to supplement its answering affidavit because there were expert reports which were filed by the applicant in the replying affidavit. So I granted them leave to supplement. And then the further order which I granted was one which said they had to approach the senior civil judge for them to allocate them a preference in the matter in view of the fact that it was an urgent matter. But the rule remained in place. I extended the rule until confirmed or discharged because I wanted to preserve the status quo in relation to the matter. I was then surprised to be slapped with a complaint when there is nothing I had done but to follow the practice directives of the division as I know the practice directive 9.1 and 9.2, which are instructive on a matter such as that one.
And the order was by consent?
The order was by consent.
Yes,
JP.
thank you, Chief Justice.
Thank you, JP. Premier?
No, thank you. I don't have a question.
JP Mlambo?
Thank you very much. Good afternoon, Advocate Chithi.
Good afternoon, JP.
Am I correct that when you were at the Mlazi Justice Center, you worked with Mr. Velamdaka?
Indeed. In fact, if I may explain that, at the time I was there, he was the regional operations manager.
Yes.
The person who was there as the Justice Center executive was Miss Zanele, the late Miss Zanele Msweli.
Oh, yes. Thank you. Your acting stints, all of them have not been term long. Am I correct?
Indeed, Judge President.
I just want your opinion. You want to be appointed permanently, but you've never faced a term-long judge's allocation. You don't think that could be an impediment?
Let me predicate my answer, Judge President, and say that it may well have been beneficial if I had acted for the full term, but I hadn't. I am confident that the 30 weeks which I had is sufficient. I have seen enough to be able to deal with the rigors of a judge.
Yeah. On average, this is my last question, CJ, in case I'm criticized. On average, how long has it taken you to hand down your judgment?
It varies, JP, and there are a number of reasons why. Some judgments, the turnaround time would be 2 weeks. Some judgments would be the full turnaround time, which is recognized in terms of norms and standards. But there are judgments where I had exceeded that time period, especially when I came back from the Eastern Cape and was acting here. That would be contributed by a number of factors. For example, there's one judgment which I have attached on my questionnaire, the judgment of Kentep. It took me quite a while to finish that judgment.
Yeah, I
And
think
I went-
Advocate Chithi, let me help you.
Yes,
Cases come with their own dynamics.
Yes.
I think that's what you're trying to explain.
yes, indeed.
All I want to know is what has been the average in terms of your judgment delivery time. You say sometimes 2 weeks, sometimes 3 months, sometimes longer than 3 months. But what average can we work on? 4 months, 5 months, 3 months?
2 months, JP.
2 months.
Yes.
Thank you very much. Thanks, CJ.
Thank you, JP. Commissioners on the virtual platform, do you have questions for the candidate?
No question from my side, CJ, thank you.
Commissioner Bredenbach?
No, thank you, Chief Justice, no question.
Thank you. Commissioner Ngugaitol?
No, I just want to ask Mr. Chithi whether the case you were discussing with the president is the case of Case Center versus Freddie and others.
Indeed, Commissioner.
No, so that's your explanation for that issue.
Indeed,
All right.
Commissioner.
Thank you, Chief Justice.
Thank you, Commissioner Ngugaitol. All right, short interview. We have run out of questions for you, Advocate Chithi. Thank you for making yourself available and good luck.
Thank you,
You're
thank you.
excused.
Thank you, Chief Justice.